Hello, everybody. My name is Tila Chalmers. I'm the CEO of the Alameda County Bar and Legal Access Alameda, and one of the partners in the Free Legal Answers California platform. We're really delighted that you've decided to become a volunteer. This video will give you just a little view of the ethics involved in limited scope representation and this platform. I'm going to cover some things that the platform already takes care of for you, but it's always good to know these things, and it's also always good to get ethics credit. So I also just want to make sure you understand what the sort of context is for this. As a quick introduction, I started out my legal career 10 years at Farella, Braun & Martel doing business litigation, a fine firm, and then I moved over to the Volunteer Legal Services Program in San Francisco and did a variety of pro bono roles, managing pro bono until I became the executive director there. Then I was a consultant nationally on pro bono and legal services, and then in 2014 I came over to the Alameda County Bar and Legal Access. So let's get started. Sometimes I think it's important to start with the definition, even though many people think pro bono is kind of like pornography, according to Justice Stewart. You know it when you see it. But here is a definition that tries to identify what is pro bono and also what is not pro bono. So what is not pro bono is answering questions about subletters for your child's school board, or working with the San Francisco Symphony, which I love, but that's not considered pro bono work. Also, boy, if I had $1 for every person who told me, well, my clients don't always pay me, so I do a lot of pro bono work. I totally get how frustrating that is, but it is not pro bono. I should mention that we do not have a legal obligation under the rules of professional conduct to do pro bono in the sense that it's not mandatory, but it is highly recommended by both our California Supreme Court and the ABA, and it's suggested that we do at least 50 hours a year, which is very little, but it really, in my view, is a part of we get a license to practice law, this incredible thing that we can do, and it's kind of part of what it takes to do that. But the fact is, it's also an amazing way to get experience and sort of learn what you're interested in, as well as helping others. So one of the most important things that we need to learn about in this context is defining the scope of representation. And for some of you, you may be pretty much familiar with the full scope model. My corporate client comes to me and says, I'm having a fight with the ABC company, I want you to sue them for me. We sign an agreement with them and we file a complaint, we do discovery, we have motion practice, we may even go to trial. The case goes on and we are on it as lawyers until the case is over, the end of trial, the end of the appeal, whatever it is. That is what we call full scope representation. But in maybe 10 years ago, the local bar association, the state bar, began to create something called limited scope. And really it was in response to middle income people who just were priced out of lawyers. And it particularly came up in family law. Look, we agree on almost everything, but you're going to tell me I have to hire a lawyer to do all the paperwork between me and my spouse when we agree on how the house should be divided and we agree on what should happen to the couch. We just don't agree on the timing of child custody or something like that. So the concept of limited scope is that you can place a limit on the time or the subject matter of your representation. You can say, I'm only going to help you today, or for this hearing, or until the settlement conference. Or you can say, I'm going to help you in your family law matter about custody, but I'm not going to help you about the property. So it's not on me what happens to the house and the couch. You guys can handle that yourself. I'm going to appear on your behalf in court and draft papers and be your lawyer for just the custody issue. As you might imagine, while it started for middle income folks, it's an enormously useful tool for us in legal services because it means that we can help more people. And some people really do need full scope. They're just not able to manage the whole process. Maybe English is not an easy language for them to work in, or their education level may not be enough, or they may have mental health challenges. But for many people, they need help really just for one piece of it. They just need enough help to move along in the process. And so this means that we can help more people because we're giving less or smaller amounts of help. The third sort of option on the continuum is self-help. That's when you give not legal advice, but legal information. So limited scope is still an attorney-client relationship. You still have privileged communications. You are still that person's attorney. You are giving legal advice. Legal information, on the other hand, is when you do not apply the law to the facts. Legal advice is when you apply the law to the facts. Legal information is when you say, this is generally what usually happens. How do I file for divorce? Well, generally you fill out these forms and then here are the steps. As opposed to a limited scope, I want to file for divorce. Okay, let's start filling out the forms for you. Let's talk about what should go into the forms. Let me recommend that you say this. Self-help happens in courthouses in every county in California now, which is amazing, mostly focused on family law, which makes sense because 80% of the litigants in family law courts in California do not have lawyers, if you can imagine. So, but it does, we see it in other arenas as well, and it can be very useful. But we're very excited about free legal answers because it is an opportunity to do limited scope, but on a platform, so that really your time is limited in a very effective way, but the client can get the answer that they want. I'm sure you were wondering, now, is this permitted in the California Rules of Professional Conduct? And if so, what's the rule number? Okay, you might not have been thinking that, but here it is. Rule of Professional Conduct 1.2b says that limited scope is A-OK. Okay, it doesn't use that word, but you get the idea. If it's reasonable, if it's in writing, if you never exceed the scope without more writing, and if you inform the client of other issues and deadlines. So it has to be reasonable. You can't say, yes, I'll take your case up until the moment of trial, but then good luck, you'll have to go find another attorney. You can't say, I'll help you with your property in a family law case, but not the couch, because that doesn't make any sense, right? It has to be in writing. I don't think I need to say anything more about that. You can never exceed the scope without more writing. So the classic story about that is the client comes to the clinic. The client has a lovely chat with the lawyer about wanting to become a guardian for their grandchild. And the lawyer says, I want you to go talk to the parents about these choices, and why don't you give me a call tomorrow and we'll just talk about it. Well, if the client signed a limited scope agreement saying only at this clinic, today only, that's it, only today, then the client is not, once the lawyer said, call me tomorrow, and the client did, now there is no scope. It's not like there's an automatically expanding scope just to how much you've done. Once that lawyer has stepped out of that box and said, call me tomorrow, then the lawyer is on it for the whole case. The whole shebang, filing a guardianship petition, serving the other side, going through the hearings, following up with the reports to the court, all of it. Now, you can have another agreement. The lawyer could say in the clinic, I tell you what, I'm happy to talk to you tomorrow about this. Let's sign another agreement that says tomorrow and only tomorrow. That's fine, but it has to be in writing. And finally, you have to inform the client of other issues or deadlines. You don't have to even know what the answer is, but you have to spot the issue for them. So, for example, there's a case involving a workers' comp lawyer. So, client is injured on the job. a construction site, client files a workers' comp claim against their employer, the plumbing subcontractor. Um, Lawyer takes the case, says, yes, I'll take on your workers' comp case, or I'll just help you with this part of it, but doesn't say you might have a claim against the general contractor. Now, general contractor is not your employee, so that's not a workers' comp claim. It's like a third-party personal injury claim. The lawyer doesn't have to know what the standards are under personal injury law. The lawyer doesn't have to know what the statute of limitations is. The lawyer does have to say, you might have a claim against a third party here, and that would be personal injury, and there are statutes of limitation out there. You know, call your local lawyer referral service, or go talk to another lawyer. You know, you do have to have informed the client of that. All right. Just in general, obviously we have an obligation to document our representation with any client. You have to have a written, we usually call it a retainer agreement, and we call it that even if there's no money changing hands, there's no financial retainer, but the client is retaining you to give them advice. I always recommend that this be in plain, easy to understand language. It should cover the payment of costs and any potential for statutory or contractual attorney's fees. I have a little beef with many of the law firm letters that I see coming from larger law firms where the risk management council has said you must always use this agreement with clients. And I understand how they got there, but it's usually 5 or 6 pages full of very long words, vetted by 900 lawyers, so every if and possibility is put in there. And often it is really challenging for our clients to understand. And you want it to be informed consent, right? So you're better off with an agreement that's just very simple and says what's true. In one of our drop-in clinics, we have a retainer agreement that says your attorney today will be representing you only today. Not after today, just today. That's really all we need. The client signs it, we sign it, it's all good. I will note that in the case of hotlines where there's legal advice being given, or now with Zoom clinics that are happening, it is acceptable for the lawyer or paralegal to say to the client, let me read you this and tell me if you agree to it. And as long as it's always the same paragraph and there's a business practice of always reading it and always the client says yes, you check the box, that is sufficient. Now in this case, the Free Legal Answers platform takes care of this for you. When you select a question to answer, the client will have already gone through accepting the retainer agreement, so you're all set. You know, before we move on to the 4 C's, I do want to mention that this is something you have to be really careful with in cocktail parties, right? Remember when we had cocktail parties? I know. But so just thinking back to that, and perhaps we'll have them in the future, or even on Zoom, you know, you get your Aunt Esmeralda who says to you, oh, you're a lawyer. Listen, I have a question. You know, I was hit by a bus, and how long do I have to file? Once you start giving legal advice and applying the law to Aunt Esmeralda's facts, you're in an engagement. And if you don't have a written limited scope agreement with her saying this cocktail party and only this cocktail party, you may be on the hook for Aunt Esmeralda. So, okay, so the representation, I like to think of it as the 4 C's. Conflicts, which is really known as the duty of loyalty, but that doesn't start with a C. So conflicts, competence, confidentiality. I added communication here. We won't be talking about it here, but it is, of course, one of the most important duties of a lawyer is to keep the client informed. And if you find yourself in the somewhat dark hobby of reading the state bar accounts of people who've been disciplined, you will see that a good chunk of them did not keep their clients informed. So that is really important, but that's not what we're going to be covering today. So let's start with conflicts. So normally speaking, when a client walks in or calls you up and says, I'd like to meet with you, you're going to run a conflicts. And if you conflicts check, and if you work in a big firm or even a medium-sized firm, it's probably going to involve going to a department and they put in every possible permutation of the client's name and the opposing party's name, and it spits out a printout, or probably not a printout now, I'm dating myself. Okay, it spits out a report that you can review, and it's quite an elaborate process. When we began having these limited scope clinics, lawyers had this idea that they would have to sit in the clinic and call their law firm and say, okay, let's see, sir, I'm sorry, what's your name? John Smith. All right, John Smith. And then at the law firm, working, late night, they would type in John Smith and say, oh, well, maybe this, maybe that. Very belabored process, doesn't work for anybody. So luckily, the ethics committees and the Supreme Court agreed that that does not make sense. So the rule is this, it's Rule 6.5. If you're doing a program through a bar association or a nonprofit program, you're giving short-term limited legal services, so that's that limited representation thing, without the expectation that the lawyer will provide continued representation. And I left the piece out that says for free, but trust me, it says for free. So it's limited, there's no expectation of continued representation, and there's no money changing hands. You only have to do the conflicts check if you know that there's a conflict of interest, if you recognize it. I like to consider it a visual conflicts check. So you're working at a clinic and someone hands you a sheet to meet with your next client, and it says the client is being sued by Bank of America. Well, you know all too well that your firm represents Bank of America. You were just at a presentation by one of the partners the other day, so you have to turn that down. But if the client is being sued by the Bank of Fifth Street and you've never heard of that, and you have no idea whether your firm's ever represented, you are free to go ahead and talk to that client. It's enormously helpful, and it applies here in Free Legal Answers too. If you click on a question and the question is, what do I do? I'm being sued, or my employer is the Bank of America. I don't know why I'm picking on the Bank of America today, but then you have to close it off and move on to the next question. Don't answer that one. But if you don't recognize the parties, you do not have to run a conflicts check. So we'll talk a little bit about competence. So competence encompasses all these things: legal learning, of course, the ability to act diligently, and the mental and emotional, physical ability to perform. So we need you to be able to be present. We need you to be able to follow through. Those things hopefully are fairly obvious. But let's talk about the learning for a second. We have given you the required trainings, and this is one of them. We also gave you links to some optional trainings, and we would love it if you'd take those, particularly the ones that are about disaster legal services, because there is obviously a fair amount of overlap with COVID, and because we'll probably use this platform the next time there is a significant disaster in Northern California. The other piece of the competence from our perspective is that we have this piece where we ask you to run all your, well, we don't ask you, we require you to run all your draft answers by expert attorneys. So we know that there is some oversight. So these are the two ways that we ensure that you are meeting your obligation of competence. The issue of confidentiality is largely the same as it is with paying clients. And actually, this is true of all ethics and pro bono. It's the same as with paying clients. Just a note that you are free to communicate about the client situation with the Free Legal Answers staff and with the volunteer expert attorney. And if you have a moment of wondering why, you can do that. I gave you here Evidence Code Section 952. Anybody to whom disclosure is reasonably necessary for the accomplishment of the purpose for which the lawyer is consulted. So obviously, both the expert and our staff are necessary for you to achieve that result. I want to say a note about cultural differences, because this really is an ethical matter. Often low-income clients face terrible choices. Do I pay the rent or do I feed the kids? How would you make that decision? If I don't pay the rent, I get evicted and we're homeless. If I don't feed the kids, they're going to starve. And sometimes we hear about people using money to buy clothes, and we think, well, wait, why didn't you pay your rent instead? Or why didn't you make better decisions about your debt? But it does take money to look good enough to get a job in order to make money. I had a client once where television really was more important than food. He was a very disabled man, and I was trying to help him figure out how to pay his rent going forward. And I looked at his budget and I said, this cable bill has got to go. And he said to me, this is how I interact with the world. And it was an epiphany for me. I like television, but if you took it away from me today, it wouldn't be the end of it for me. But for him, it was his only contact with the outside, and it was really more important than I had understood. And people sometimes make decisions that you or I would look at and say, this is not the best decision for you, but they needed to be happy now. And I think all of us might be able to look back at a time when we were, if it's not now, when we were living on a strict budget, and yet sometimes we, bought a candy bar or got a milkshake because we needed it. We needed it right then, and it was important to be happy. So it's important to think about these issues and to really be focused on not being judgmental of your client. Because your role is to explain what's happening, what you can expect to happen, and what the client's choices are, but not to make the decision and not to judge the decision. We see this a lot with clients who decide to settle when we think, they have a good case. And it's not our decision, and their decision might be based on their assessment of the stress level in their family, or cultural or socioeconomic or even religious issues that you don't know about. And really, this is exactly the same for paying clients. We don't think of it that way, but it is completely true. So try as much as you can to make your head a judgment-free zone. It's also really great to ask questions. When you're meeting with a client face-to-face, you can say, tell me about that. Why is that important to you? Why are you thinking you're going to make that decision? And just listen. It's not going to change, but it might help them and you if they say, well, this is going to happen if I don't do this, and that's wrong. You can correct that. But it's also important for all of us to keep learning what it's like to walk in other people's shoes. Okay, so we have a hypothetical, which this is being recorded, so you can all chime in. So Jane, volunteer attorney, answers a question for a client on the FLA platform. Is it representation? Well, yes, it is. It is limited scope representation, and it's totally fine because the platform is getting it in writing, and it's reasonable. We are ascertaining that. The importance for you is to not go outside the platform, because then you'd be stepping out of that box, right? And then the world is opened. So Jane has a back and forth with the client to clarify the question and the answer. So Jane says, I'm not quite sure I understand your question. Are you a gig worker, or are you an independent contractor in some other way? The client responds, Jane gives an answer, the client asks a question about that answer. This is completely fine because the scope is the dialogue on the platform. So it's fine to go back and forth. Now, at some point, you may feel that we're done here, or the client's needs are so great that it's really time for the client to get a lawyer to look at it in a more long-term way. But it's okay. Okay, now what if Jane really is enjoying the exchange and she feels that she could help this client by drafting a letter for him? Maybe calling the opposing party. Can she do that? Hopefully you are shaking your head at your computer right now because, I mean, yes, she can do that, but only if she opens up a new case, has a new retainer agreement, does a conflicts check, and clears it with whoever else she reports to. Because this is a brand new case. If she goes off the platform, the malpractice insurance that the ABA provides the attorneys who come on this platform, that insurance will not apply. And if she doesn't have a new retainer agreement, she risks now handling this case from soup to nuts. So we ask you largely not to do this. And if you're going to do it, just alert us to that fact and we can help you remember all of these requirements. We will have lots of places where you can refer people for further help. So take comfort in that. Okay, so that, my friends, is the end of my presentation. Here you have my contact information. I would encourage you to write me or call me with any questions that you have, either now or as you go along. I am more than happy to talk. I'm showing you that by giving you this ridiculous picture of myself. So, thanks again for your attention. I really appreciate it. And I'm looking forward to seeing you on the platform. Take care.